In recent weeks, the Department of Homeland Security has initiated a sweeping campaign of visa revocations and SEVIS terminations targeting international students in the United States. While headlines have focused on crackdowns related to speech and protest, a parallel, quieter purge is now underway. One targeting students based on the mere presence of a criminal record, often for minor or even dismissed infractions. The method is blunt and bureaucratic. The government flags a record, issues no charges or notice, and terminates the student's SEVIS record under the vague label of identified in criminal record check. No further justification is provided. What follows is an erasure of legal status, outside any courtroom or administrative hearing, enforced through a system designed for compliance, not adjudication. But what makes this moment most dangerous is not the action of federal authorities alone. It is the silent complicity of the universities themselves, and in particular, the role that has now been assigned to designated school officials, or DSOs, not as advisors, but as enforcers. The government has engineered a mechanism that ensures international students cannot challenge these terminations, because the very institutional actors they depend on to access due process have been convinced or coerced to stand in the way. The legal procedure for reinstating F1 status is well defined. If a student falls out of status, they may, within 5 months, apply for reinstatement using Form I-539, but only if their university DSO provides a reinstatement I-20 tied to the same SEVIS ID. This I-20 is not a statement of innocence. It is merely a procedural gateway, a key to the courthouse door. Without it, reinstatement is legally impossible. And so the strategy reveals itself. DHS terminates SEVIS records without evidence. Universities refuse to issue I-20s without evidence, and students are left in the middle, deprived of the tools to rebut the charges or even see them. Procedurally, it's the perfect crime. The agency avoids having to justify its actions. The institution washes its hands of responsibility, and the student is expelled from the system, invisibly and without recourse. What makes this not just outrageous but intolerable is that DSOs, many of whom have served as tireless advocates for their international students, are now the final mechanism through which the government's procedural denial is operationalized. And we should be clear, many of them are not willing participants. The University of Illinois, for instance, recently issued a notice to affected students stating that it could not provide reinstatement I-20s. That statement is not neutral. It is the end of the line. This is not a matter of institutional confusion or legal ambiguity. The federal government has deliberately positioned non-governmental school officials as the intentional bottleneck to block students from accessing the statutory process Congress has provided. It is not just that the reinstatement process is difficult to navigate. It is being actively denied through institutional non-participation under what appears to be informal threat of DSO decertification, a coercive silencing enforced through fear of losing SEVP certification altogether. This is the crux of the matter. SEV does not need to terminate students by rule if it can terminate them by silence. That silence must end. We must be absolutely clear about what is happening. International students are being denied access to the legal remedies afforded to them under law, not by explicit prohibition, but by strategic obstruction. And the responsibility now lies with those closest to the students, the DSOs and university administrators to say so. Some may feel powerless in the face of federal pressure, but there are two immediate actions institutions and DSOs should resolve to take, and both would amount to a quiet revolution. First, issue reinstatement REI 20 forms as a matter of institutional conscience and procedural fairness. Students who have committed no crime must have an opportunity to make that case, and reinstatement is the only available process. Make clear that these documents are issued not to endorse a set of facts, but to allow lawful adjudication by the proper authority, USCIS. Nothing in federal regulation prohibits this, and everything in the rule of law demands it. Second, if issuance has been explicitly prohibited, speak publicly about the nature and source of that constraint. If SEVP or ICE has directed DSOs not to issue these documents, that instruction must be surfaced, documented, and challenged. If DSOs are being threatened with a decertification for acting within the bounds of the law, and universities threatened with removal from the student visa program, that is itself a matter of national concern. This is not about politics. It is about process. No government should be permitted to take action against individuals while simultaneously denying them the right to argue the facts on which that action is based. And no university should cooperate in a scheme that strips its students of the right to defend themselves in the system they entered in good faith. The SEVIS database was not built to serve as a black box of enforcement. It was built to track compliance and enable communication between institutions and the federal government. It was never intended to become the very wall that prevents students from accessing justice. If DSOs and universities remain silent, they become, however reluctantly, instruments of a policy that achieves removal through the back door of deactivation. But if they speak, if they act, if they assert the minimal procedural standards that any student or citizen would expect, then we will have taken a first step toward restoring integrity to a system now on the edge of collapse. The choice is no longer with DHS. The choice is now with the universities. And in that choice lies the future of every international student facing the silent knock of digital exclusion.